Hi, my name is Andrew Marsh from TU Dublin Hothouse. Today is the 5th session in our series on creating a spin-out company. Before today, we've talked about how to create a business model, if you should consider creating a spin-out at all, how to get funding, and other topics. Today we're going to focus on patents and intellectual property. For a tech-based business, to get investment, you need to have a very, very clear picture to your investors about what is the intellectual property within that business. I'm delighted today to have Kate Hickinson and Howard Reid from Appleyard Lees. They're both partners with Appleyard Lees and very experienced patent agents, patent attorneys, who are going to give us an overview of patents and IP, in particular as it applies to early stage business. If you have any questions, just pop them in the chat and we'll address them at the end, or you can ask them in person at the end if you'd prefer.
Hi, I'm Kate Hickinson, a patent attorney and partner at Appleyard Lees. We are here today to talk about basics of intellectual property. At Appleyard Lees, we handle all types of intellectual property, and I myself am a chemistry expert, so I have a degree and PhD in chemistry, but I'll pass you on to my colleague Howard Reid now, who will introduce himself and begin our presentation.
Kate, thank you. As Kate's introduced, I'm Howard Reid, also patent attorney with a background in material science, but also in computing. We're going to talk through some of intellectual property basics. And I'll start with the fundamental question, what is intellectual property? Or perhaps you know it as, what is IP? Now, intellectual property or intellectual property rights protect intangible assets. Now, we're all very familiar with tangible assets, whether it's the desk the laptop is on, the laptop itself, or even a house. But intellectual property thinks about creations, about ideas, about abstract concepts, perhaps. And this brings its own challenge. Now, with tangible assets, we know how to value a tangible asset. You can see it, you can represent it, we know what it is. But intellectual property, potentially being purely an abstract idea, is far more difficult to quantify. How do you put a value onto an idea? Nevertheless, the value may be considerable. And when we start to think about branding, that we'll talk more about, the value of the brand could actually be worth more than the value of the goods or services themselves. What are the different types of intellectual property? And here we're just thinking about 4. There are indeed others. And we'll start with perhaps the oldest and one that you're probably quite familiar with, because it features often in the news. And that's copyright. And copyright protects against literally copying. And it goes back to the days of wanting to stop someone when they're thinking about printing presses from copying, from reproducing a facsimile copy of what was being done. So it applies to art, to literature, to music, to drama, even to source code for software. What you're also going to be very familiar with is the idea of branding that is protected by a trademark. And a trademark is used to signify the origin of goods or services. And it is that reputation that's associated with that trademark that brings its value. So when you ask for something by name, that is because you're asking for it for the reputation that it has. Continuing through, designs. What is a design? Well, a design, a registered design or even unregistered, protects the physical appearance, the aesthetics of goods. So whether we think about the surface texture or finish, or whether indeed the form, this is what is protected by design rights. And finally, of these, the perhaps most abstract is patents, which protects inventions, and we're going to talk quite a lot about these. Now, a patent, particularly, may be almost an entirely abstract concept. You are protecting an idea. Yes, you'll have an embodiment of it, perhaps, but you're protecting an idea. Now, as shown on these slides, patents, trademarks, designs, copyright are all shown separately, and that is purposeful. because they are different and separate rights. Even though an object, a product, or a service may have or may be protected by each of these rights, yet they're all distinct. So if we consider something as simple as a branded trainer, then the drawings of the trainer, the footwear, will be protected by copyright. The logo will be protected by a trademark. The aesthetics protected by design right. And then the material, or even the design of the sole, the shape of the sole, could be protected by a patent. These are the different rights that we have available to protect what you have created. Now, of these different rights, some are registered and some are not registered. Well, what is the difference? Well, copyright, for example, arises automatically upon creation of a work. So the moment you write something down, provided it has a degree of originality, and that can simply be it originates from you, or the moment you take a photograph, then there is copyright existing in that. Whether there's value in it is a different matter, but the copyright arises automatically. Similarly, a design right arises when you design a product. And you will have also probably seen a brand name, or perhaps a brand name, followed by the letters TM, the acronym TM, to stand for, and this is purely an unregistered trademark. What about registration? Some rights, patents, registered designs, and indeed registered trademarks, you have to apply for them. And often these rights, or obtaining these rights, is via examination. So that particularly applies for patents in most jurisdictions, designs, and trademarks. What we have then, particularly where the rights are examined, is that enforcement of those rights is facilitated. And you may think of them as stronger rights. With such rights, generally, you don't actually have to show that there's been copying. So if there's an independent deviser of what you have designed or what you have invented, then that is irrelevant. The point is, if you have a right, a better right to that invention or to that design or even to that trademark, you are the right holder. And that means that somebody else can still infringe. And by infringe, that means they are doing an act that you would otherwise have to authorize. There is always a question about intellectual property as to its worth, and it is an important consideration. Particularly, as we're going to talk about with patents, there is maybe significant investment in securing, particularly the registration of the intellectual property rights. So the question is, should or is such registration worthwhile? If you're a Spinout, for example, Spinout from TU Dublin, then you have to think about what value is there in the Spinout other than the people, appreciating that people are generally the greatest resource that any Spinout has. Well, you have to think about what you have been creating, what intellectual property have you brought and have you got in your Spinout. Having, whether it's pending patent applications, may help secure investment or attract commercial partners, or even demonstrate your competency, your knowledge in your particular field. This is particularly important when we start to think about inventions where validation or proofing is required while you're bringing them to market. Because to go from abstract concept through to marketable technological readiness may be a significant time. And we can be talking 5, 10, 15 years. This particularly applies if we're thinking about pharmaceuticals or biotech. If we're into the software space, things happen more quickly. Even for hardware, there may be regulations that have to be met in order to bring the products to market. Who are you looking to for your investment in your Spinout? Well, traditionally, we have to say UK and more generally Europe has been relatively cautious when it comes to investing in spinouts, as I'm sure you're aware. But that's because of historical desire to not incur risk. whereas if we look at the US, investment is far more readily available. And the pandemic has not helped in terms of obtaining investment, though this is sector dependent, and we're beginning to pull through from that. But whatever we look at, we do see that intellectual property, particularly registered intellectual property, and especially patents, are valued by investors. As a little evidence of this, this is a recent report prepared jointly by the European Patent Office and the European Union Intellectual Property Office. The EPO, as it's known, the European Patent Office handling patents, and the European Union Intellectual Property Office handling European registered designs and registered trademarks. And they're looking at the value that intellectual property rights, IPRs, may bring to particularly small businesses. And in their study, they showed that not only were companies or SMEs that had IPRs significantly larger, but also the revenue and the wages earned by such employees of such companies was also significantly higher compared with organizations or SMEs that did not have any intellectual property rights. In this case, the intellectual property rights that they were looking at were patents, trademarks, and registered designs. So having IP brings value to your organization, and that brings also monetary benefit to the employees.
Okay, so that was an introduction to IP generally, and now I'm going to talk a little bit more about patents, which perhaps would be your main focus at TUD. So firstly, what is a patent? So as Howard has just said, a patent is an intellectual property right that protects an invention. So by an invention, we mean something technical, not the look of something or the name, the actual technical invention. And a patent is effectively a contract with the state. So it's a right to stop someone else working your invention for a period of a maximum of 20 years. That's dependent on the payment of fees. But in return for that, you have to fully disclose your invention to the public. So you can't be granted a patent if you're not prepared to provide full details of your invention to the public. And this is what we call sufficiency when we're looking at patent applications. So the Patent Office will examine your application for sufficiency and decide whether you have disclosed your invention in such a way that would enable somebody else skilled in the art to carry out your invention. And if you haven't, then you won't be granted a patent. So you can't have a patent if you're not prepared to actually disclose your invention fully. But a patent isn't actually a right for you to exploit your invention. And this can be quite a difficult concept sometimes to understand. So if you have a patent, it doesn't necessarily mean that you're free to use the invention protected by that patent. So it doesn't mean that you necessarily have what we call freedom to operate. And an example of that might be, in my field, if one party has a patent granted to a new chemical entity, so to a pharmaceutically active compound, they can have a valid granted patent to that compound. A third party might have another patent, for example, that covers a combination treatment. And in that patent, the two different actives may be defined generically, so they might be defined functionally or more generically, in such a way that one of the definitions might cover your compound. So whilst you have a patent and you could use your compound in some ways, if there was a third party that had a patent that covered a combination, including your compound, you wouldn't be free to just use it in that way, just because you have a patent directed to the pharmaceutically active compound itself. So the patent document itself is the contract, and it defines the scope of protection that's offered. And in the patent specification, we have what are called the claims, and the claims define the scope of the invention for which you're given protection. That's different to the description, which is more of a discussion and supporting of the subject matter that supports the claims. And the aim is to get the broadest protection that you can possibly get for your invention whilst also having a validly granted patent. Okay, so a patent protects an invention, but what is an invention? So an invention has to be something technical. So it's not what something looks like or what the name is. It's actually a technical invention. And generally, an invention solves a technical problem. So when I'm talking to inventors about how we're going to define their invention and what is actually the core of their invention, I often ask them about what difficulties they've encountered whilst they've tried to develop the invention. And often that discussion brings about a real understanding of what the invention is. So often overcoming those technical difficulties is part of the invention and leads you to making something new and inventive that's actually useful in a technical way. So an invention also doesn't have to be a completely new thing. So in the area of chemistry, it doesn't have to be a new compound. We can also protect new uses of known compounds or combinations of compounds. So I think sometimes people think that an invention has to be something that is totally, completely new, and that's not the fact. So an invention can actually be an improvement over something that's already known. And we've got on the slide there some examples of the sorts of things that can be inventions. So including methods and devices or components of a device, compositions, uses, medical products. So it's good to think about inventions quite broadly. And then to be a patentable invention, the invention needs to be examined against some legal criteria, which we'll talk about later. And there are some exclusions due to policies by the patent offices. We've talked about patentable inventions, but it's worth just mentioning trade secrets or know-how. So as we discussed earlier, a key part of the patent process is actually disclosing your invention and telling the public full details of the invention. So another option is to simply keep your idea or invention secret. And then your invention will be protected by virtue of being confidential. Now, this may make sense for some inventions in some technical areas, but not in others. So in the chemical field, for example, if you have a chemical compound and you've optimized the process for making that compound, you might have tweaked certain parts of the process, which really helps you to make it, particularly on a large commercial scale. And you may decide to keep the details of those process optimizations secret, so as not to help your competitors to make the compounds in the way that you can, especially if you cannot tell from the final product how it's been made. But the problem with this approach is obviously that it can be difficult to keep details secret and information can leak out. There's also the issue that third parties can also invent what you've invented independently and protect it with a patent. And in some cases, that could be used to stop you doing what you wish to do. So Howard and I introduced ourselves as patent attorneys, and as patent attorneys, it's our job to bridge the gap between the legal and the scientific. So when you wish to protect your invention with a patent, we really recommend that you discuss how to do that with a qualified patent attorney. So we help our clients to get protection for their innovation. And all patent attorneys have at least a first degree in science or engineering, and mostly now patent attorneys would have a PhD too, and often industrial research experience. Both Howard and I have worked as research scientists before training as patent attorneys. But we then train in patent law. So we train on the job and we take exams to become qualified as both UK and European patent attorneys. So we don't have the same in-depth knowledge of each invention as the inventors. We rely on the inventors to share with us their technical expertise. But because of our scientific backgrounds, we can quickly understand the inventions and ask the correct questions that we need to really understand from the inventors how an invention works and what are the important aspects of that. So now I'll pass on to Howard, who will talk a little bit more about what is patentable.
Thank you, Kate. So what makes an invention a patentable invention? Common to all jurisdictions are some fundamental requirements for a patentable invention. Your invention must be new, also known as novel. Your invention must have an inventive step or be non-obvious. And your invention must also be industrially applicable. They're all positive features about your invention, but there is something else that your invention must not be. your invention must not be excluded or patent ineligible. And we're going to look at these in more detail, starting with, indeed, the industrial applicability and excluded subject matter. Given the long history of patents, your patentable invention has to be capable of being used in industry or commerce, and this includes agriculture. And you may ask why there is this requirement. Well, it helps us to distinguish from perhaps a perpetual motion machine or even cold fusion, which great ideas, but are not patentable inventions. A bigger question perhaps comes around excluded subject matter. And excluded subject matter in the US, known as patent ineligible subject matter, are where, for policy reasons, the government has decided that inventions, whilst otherwise worthy of being patented, are not to be patentable. And these include, amongst others, discoveries. So if we discover something, you can't patent the discovery. However, that doesn't stop you from patenting perhaps use of what you've discovered, or some way of synthesizing it, or including it in some process. Similarly, a theory should be free for all to use, as should a mathematical model. Computer software receives a lot of press, and there is this popular exclusion of computer software. But there is a proviso. Computer software as such is excluded subject matter in the UK and Europe, for example. But computer software, when it is part of something that provides what is known as a technical effect, is indeed patentable. And that is what I do a lot of my work on. In addition, in the UK and Europe, but not in the US, methods of treatment, surgery, and diagnosis are also excluded. The idea behind this being that medical practitioners should be free to practice treatment, surgery, or diagnosis without infringing a patent. Nevertheless, the particular prescription that is being prescribed, or, for example, a stent that is being used in the surgery, or even the AI software that is being used to help diagnosis, these can still all be patented. What is excluded are the particular methods that then the medical practitioners would use. So moving then from industrial applicability and excluded subject matter, what are the positive characteristics or features of a patentable invention? Well, we said that your invention must be new. So what does this mean? It means quite simply, the subject matter of your invention, the key concept of it, cannot have been made available to the public prior to the date of filing of your patent application. What you will often hear, particularly examiners talk about, is the prior art. And prior art are often documents, but not limited to such, that are made available in any way, in any language, at any time before the date of filing. If it was made available on the same day as you file, it's not prior art. But anything made available before can be considered to be prior art, even if it's difficult to access. And what is typically now prior art? Well, patent documents are, and they're well indexed, so they're easy to search for, but so are journal publications. Most things that appear on websites are already form part of the prior art from the day that they become available. And proving that something was made available via a website is relatively easy using, for example, the Wayback Machine. Also amongst prior art are oral presentations or uses. So if you disclose at a conference your invention, then this can be prejudicial to obtaining a patent for your invention. There are some jurisdictions, such as the US and Japan, where you can swear back to your own prior disclosure, but that is generally something that we don't want to rely upon. and it does not apply in jurisdictions such as Europe. So that's novelty. Your invention has to be new. It cannot have been done or anticipated before you file for your patent application. I want to emphasize disclosures made by the inventor. That is, perhaps somebody in your team, even if it's not you. Such disclosures, and they may be relatively informal, such as some comment on a blog, something on some crowdsourcing, or even a post on a website, can be considered a disclosure that could prejudice patentability of your invention. And unfortunately, this is still something that we continue to see with academic institutions. We understand entirely the pressure that academics have, such as yourselves at TU Dublin, to publish. But unfortunately, such a publication may be prejudicial to your patent. That is, you may not be able to get granted a patent, or if you do, it may not be valid because of your own publication. We see this increasingly with pre-publication of, particularly in electronic journals, where a preview of the article is published in advance of the publication date, which may be several weeks or even months before. You need to speak, and the Tech Transfer Office needs to know about all potential publications when they'll be, such that we can file a patent application in good time. And by in good time, no later than the date on which your publication became available to the public. Once the application has been filed, then you can publish. Though there's always a question that your publication, particularly if you're making improvements, then becomes relevant to patentability of those improvements. So again, if you're at an early stage in your research project, do discuss with your patent attorney, with the Tech Transfer Office, about filing for future IP, thinking about your publications. That was novelty. Your invention has to be new. The other fundamental requirement is that, and this is perhaps the harder bar to achieve, is that your invention, to be patentable, must comprise an inventive step. It must have some advantage that is not obvious. So what do we mean by that? Well, partly it depends on which jurisdiction you're working in. In the UK, for example, a non-obvious development of the prior art is where the advantage, the benefit conferred, is not available from the common general knowledge. So what you might have in a textbook, for example. In Europe and in the US, an inventive step arises, particularly if your novel feature is not arrived at from a combination of two or more documents, or more generally, two or more pieces of prior art. So think of mosaicing two documents together. If you can combine them and they arrive at your invention, then unfortunately, it's unlikely that you'll pass the inventive step hurdle. For this combination of these two pieces of prior art, well, they're usually in a similar technical field, but they don't have to be. And we've got a couple of examples here. If we are using a door handle that is already known, and we're now using it on a window, given that they both relate generally to construction, then it is probably obvious to take that door handle and apply it to window. However, if we take something, in this case, sealing a satellite housing, we're now thinking about launching something into orbit, and that technology has been arrived at, or could be arrived at, from manufacturing or sealing tins of soup, it is not likely that a person, or an inventor, a skilled person, as they're known, working in the field of providing sealed satellite housings is going to know about canning. And so there may be the opportunity there to obtain the grant of a patent because we have overcome the inventive step hurdle. Now, it's popularly thought that the inventive step hurdle is a very high bar. But your invention doesn't have to be groundbreaking. What you have to have is an advantage. If it's a chemical engineering process, for example, even a fraction of a percent improvement in efficiency, and this would apply even to an internal combustion engine, for example, would be enough to confer patentability. Generally, we've been talking about applied research, where you're going to have a product. But there are occasions when the product is not as yet envisaged, or the research appears to be relatively more fundamental or at an early stage. That is not a barrier to patentability. The question, though, is whether you should file for a patent at this stage or later. And that partly depends on maturity of your invention, of the development, and the future developments. And weigh in with this, how and when you are going to raise revenue, raise investment towards, for example, your TU Dublin spinout.
Okay, so if you talk to the tech transfer office and it's decided that you have an invention that's patentable that you'd like to protect, then the first stage is to draft a patent specification. And this is usually done by a patent attorney. And what I would usually do is sit down with the inventors and discuss the invention and what the inventors think is patentable, but also hopefully get an idea from the inventors as to what the prior art is, what the inventors are aware of, and try and really hone in on what are the novel features that we want to claim, make the subject matter of our claims. So as Howard's just discussed, there's the requirements of novelty and inventive step. Novelty is quite a black and white thing, so usually we can just decide that something's novel or not. But obviously inventive step's a bit of a grey area, and there's often an argument that can be made that something is inventive and an argument that can be made that that thing perhaps isn't inventive. So I think when drafting claims initially, I certainly concentrate on novelty with an eye on inventive step, but we want to make sure that we're drafting claims that are novel. So it's really helpful if the inventors have an idea of what the prior art is, so that we can, right from the early stage, concentrate on the features that are novel. So we start off by drafting the patent specification, and probably the most important part of the patent specification is the claims. So as we've already discussed, the claims define the scope of protection that you get. And there are two different types of claims. We have independent claims, which are standalone claims that define the broadest aspect of the invention. And then we also have dependent claims. So dependent claims refer back to an earlier claim and generally include preferred features of the invention. Now you might wonder why we include all these different claims. Once the patent specification is drafted, if we want to make any amendments to the scope of the claims, that can only be done based on what has been included in the specification as filed. So often we might have to narrow the scope of a claim based on what's in the application as filed, and often we will rely on preferred features that are set out in the dependent claims. So we draft the claims first usually, and it's really important to think carefully about the scope of the claims that we're drafting. So a patent specification also includes an introductory section. Generally, that can be quite brief, just setting out what the field of the invention is and perhaps some of the problems. We used to put in quite a lot of discussion of prior art, but we try not to do that now for various reasons. So we try to have quite a brief introduction to the invention. And then we have a description section, which is more lengthy. And the description is used to interpret the claims. So you might, in the description, define some of the terms that are used in the claims. And again, subject matter from the description can be used to interpret the claims later on, either in examination proceedings or infringement proceedings once a patent's been granted. We also often have examples in a patent specification, particularly in the field of chemistry. So you might have examples that show how you made your chemical compounds or your chemical composition, and also information on how those compounds act in certain ways. So if it's a pharmaceutical compound, showing that they have activity against a certain target, or if it was a composition showing that it can be used in a certain way. I find it really helpful when drafting a patent specification if I have the examples right at the start, because then it just really helps to understand the invention and see what it is that we want to claim. We're often asked, how many examples do you need for a patent specification? And there's no easy answer to that. Often it's useful to have quite a few, but there can be circumstances where you might file without examples. The examples can be used to support the claim scope. So if you're claiming a very broad area, then, and you have one example, the examiners often don't like that. So if you want to claim a new area, say it was a completely new type of chemical compound and you wanted a very broad generic scope, you would generally need more examples to support that scope and show that the broad definition of the compound actually is active across that whole scope. But it does vary, and it's really good to talk to the patent attorney when you're drafting about what examples you've got. It's also often really helpful to see examples that didn't work. So that can help to identify, again, what it is you want to claim. So I often like to see the examples that didn't work as well, to try not to cover that, and to, again, really emphasize what the novel feature is. So often in patent specifications, there's also figures, particularly if it's a device type application. So you might have figures that show how the device is put together or the device works. In chemistry, we might have figures that show some of the data. So that's the patent specification, and it needs drafting really carefully. I think a patent specification needs to be clear, so it needs to be easy to read. And it also, of course, needs to be technically correct. So when drafting, I always ask the inventors to tell me if they think something's unclear or not right. You know, we really need to get it right at the start. And I would much prefer that an inventor told me that they thought something was unclear or not quite right. You know, when we're drafting it and we can change it, then find that we have issues during prosecution. And as I said earlier, the inventors are the experts in that particular technical area. So we rely on you to help us out with that. Okay, so I've just included a few examples here of different types of claims, because the claims can vary very widely. So I'm not going to go through them all, but we just have a couple of chemical type claims here where we've got a compound of a certain formula, and then we define the groups that can be found on the core. Or we also have a claim to a solvent-borne binder, and in this case, we are defining that by including a copolymer that's obtained by reacting a certain composition. So that might be appropriate when it's not very easy to define structurally the copolymer that's formed. So there's lots of different ways to claim subject matter and to draft your claims. And then here we have a couple of claims to devices. So we have a hydrogen storage device, which comprises certain technical features, so a first vessel having an inlet and an outlet. So that's more of a mechanical type invention. Also a claim to a manhole, which again is defined in terms of the components of the manhole. So okay, once you have drafted your patent specification, then what's the process from going to that to a granted patent? So generally we file that first application, and it's called a priority application. We generally would file that as a GB application at the UK IPO. We often file that with a request for a search. So the UK IPO will search the claims of your application and provide a search report which lists prior art that they think is relevant to the novelty and inventive step of the invention. This is done for a fairly low fee and is a really good way to get an idea as to whether your invention might be patentable right at the start. So we then have what we call the priority period. So you have a period of 12 months from that first filing in which to decide whether you want to file in any other countries or regions. So you need to have a patent in all the countries, individual countries where you want patent protection. So what's often done at the 12-month stage is we file an international or PCT patent application. And this covers most countries in the world, not all, but most. And that application continues for a period of time as a single application and will again be searched and examined by the Patent Office with which it's filed, which again gives you more information as to whether what you've drafted or what you've invented is patentable and likely to result in a granted patent. What I should have included on there is the fact that the patent application is published at 18 months from the first priority date. So as we said before, you have to disclose your invention and the invention will become publicly available for other people to look at. But you do have that period of it's 18 months until publication. So if you first file your application and decide, actually, when you look at the GB application, the priority application and the search report that's issued, there is a possibility to withdraw it if you decide that actually it's not patentable or there's some prior art come up that you weren't aware of that's going to cause issues and you maybe want to do some more work or claim it in a slightly different way. There is a possibility to withdraw that application before it comes publicly available and refile. But once you continue with your patent application, the patent offices where the applications are filed conduct a search and examine the claims as filed to determine whether they think they are novel and inventive and also meet the other requirements of patentability that were discussed earlier. And we get what's called an examination report or an office action issued where the examiner sets out any objections that they have to the claims. And it's our job as patent attorneys to review those objections and either argue against them or amend the claims slightly and change the claims in a way that will convince the examiner to allow the application to proceed to grant. Obviously, when we're doing that, we're also trying to keep the scope of the claims as broad as we possibly can to give you the broadest protection. Different scenarios, sometimes you might take a narrow claim to get something granted quickly and then pursue what we call a divisional application to get broader scope. But basically, it's our job as patent attorneys to convince the examiners at the different patent offices that they should grant you a patent. So hopefully, after that process, you do have the grant of a patent. And as we said earlier, the patent can last for 20 years from filing, provided that you pay certain renewal fees.
Thank you, Kate. Let's think about more of the practicalities in particularly applying for a patent application. We talked about disclosures even by the inventors, but who is the inventor? Is it one person? Is it more than one person? For a patent to be granted, the inventor must be named. They have the indeed right to be named on a patent. And so that must be included. But who is the inventor? And that may change during prosecution of a patent, because what we have to do is identify the inventive concept of the granted patent. So there may be a larger set of inventors on the application than indeed on the granted patent. However, that is usually not considered. But certainly, the inventors might not be everyone engaged on the project. So identify the inventive concept, who contributed to that. And this idea of inventorship and who the inventors are is entirely separate from who the owners are, but is linked. Generally, the owner of or proprietor of a patent or a patent application when applied is the inventor or inventors, unless the law provides otherwise. And the law may be via statutory law, which it is common in many jurisdictions that an employee, or rather the invention invented by an employee, belongs to the employer. This might also be via a contract of employment or some other agreement, such as a subcontract agreement. Not only that, but intellectual property, being property, which you can indeed license or even mortgage, can also be assigned. So you can assign the rights of your invention to another party. Even your rights in the invention may be jointly owned. And that is always something to be considered, and I'll use the word carefully. And this is particularly important, as we'll talk about in a moment, when we're thinking about collaborations and we're thinking about projects involving a relatively large team. Because you need to establish, really from the outset, who owns what. This can be done via a collaboration agreement, and it is always good to have this written down clearly at the start. As you work through the project, keep a good record, accurate record, of what is done, so you can identify who the inventors are. And echoing what Kate talked about earlier, focus on the challenges, the problems that have been solved or overcome, because it is in overcoming those challenges that you may be inventing. So knowing who overcame the challenges, knowing who solved the problems, may identify who the inventors are, and hence who the owners are. And as we stress, this is exceedingly important for collaborations. If, for example, TU Dublin is working with another organisation who are perhaps providing funding or technical expertise, there may be a relationship as to, and as such, an agreement as to who owns what. Often, what is termed background intellectual property will be identified. This is the intellectual property that the parties, the collaborators, are bringing to the joint project. And then what is being further developed as part of the project is the foreground IP. And you need to understand and define who owns what. It may be that the foreground IP is jointly owned. It may be that the foreground IP, that is the IP that is developed during the project as part of the collaboration, belongs to the party that, the collaborator that invented it. Meanwhile, background IP generally stays with the party that brought it in, but there's always a question as to whether that background IP will be licensed to the other parties such that they can continue to work, for example, the invention, if the invention is dependent on that background IP. So get agreements into place and get those into place early. The last one, and we'll just reinforce what we're saying about disclosures, it is imperative in almost all jurisdictions that a patent application is filed before, or at latest, the day of a public disclosure. So contact the TU Dublin Tech Transfer Office if a publication, or oral presentation or internet publication is likely or anticipated. What you do need to be clear about is what is going to be disclosed and when. It could be as simple as a marketing brochure that is advertising something that is forthcoming. It might be that you the abstract for your talk is going to be published. But often that abstract could be what the essence of an independent claim. So we don't want that published before a patent application is filed. And this must all be done also in conjunction with your collaborators if you're working in a collaboration. Now, if disclosure is imminent, patent attorneys can and will react responsively and may, if required, file patent application on the same day. And both Kate and I have done that previously. Not ideal, but it can be done, and it can potentially then rescue what would otherwise be non-patent, something that is now prejudiced by such publication. So talk to your TU Dublin Technical Transfer Office if a disclosure is planned.
Okay, so this is just an example to finish with of a client of one of my colleagues, Simon Bradbury, who's a biotech attorney. So he has a client, SkinBioTherapeutics, and the technology for this company was derived from the University of Manchester and relates to skin health. So our client, Appiod-Lees' client, SkinBioTherapeutics, entered into a joint venture with the university. And what this entailed was extensive due diligence. So Appiod-Lees looked very carefully at the patent portfolio that was existing, what had been claimed, how the applications had been put together, what prior art had been cited, what might get granted, and really looked at the patent property that was associated with this technology derived from the University of Manchester. And the patent portfolio was then handled by Appiod-Lees going forward. So in this case, the company that resulted floated on the London Stock Exchange and raised over £20 million, which was released equity back to Manchester University. So the point I wanted to make here was about the extensive due diligence. So in order for that deal to happen, the patent portfolio was looked at very carefully. So it is just really important to get everything right, or as right as possible at the start, and think really carefully about what we're claiming, how we're drafting, things like inventorship that Howard's just talked about, who actually owns the inventions. All of that needs to be right for a collaboration like this to go ahead. So it's just to emphasize the fact that all of the issues that we've talked about are really important for spin-outs and if you want to attract funding and take your business forward. Okay, so hopefully you found our presentation interesting and learned something from it, and we would imagine that hopefully it will have raised some questions in your minds, so either for us or for you to take to the tech transfer officers at TU Dublin. So some questions there that you might think about, but really we just want to emphasize that it's really important to think about IP protection before you publish your inventions, and have a mind on patentability as you conduct your research and your plans.
Kate, thank you. Indeed, thank you for joining us today. As Kate said, if you've got any questions, get in touch. We'd always rather you talk to us before. We can sort things out then. We can't always sort things out after. So if you think there might be something patentable, get in touch.
So thanks for that talk, very interesting, and I'd like to open it up now to see if there's any questions.